mahasiswa yang mungkin masih belum selesai perkuliahan. Baik, bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Terima kasih atas kehadiran Ibu Dina Imam Supaat yang sudah berkenan untuk memberikan perkuliahan pada pagi hari ini, khususnya kepada mahasiswa kami Fakultas Hukum UTM, khususnya lagi pada mata kuliah Hukum Internasional. Sebelum materi kami berikan kepada Bu Nina, kepada mahasiswa semua, perlu saya sampaikan terkait dengan kurikulum vitae Bu Dina ya. Nanti saya minta kepada mahasiswa untuk memperhatikan dengan baik. Di akhir penyampaian, saudara bisa memberikan beberapa pertanyaan, khususnya yang berkaitan dengan pokok diskusi pada pagi hari ini. Bu Dina adalah Dokter Dina Imam Supaat. Beliau merupakan dosen senior di Fakultas Syariah dan Hukum Universitas Sains Islam Malaysia. Beliau memperoleh gelar doktor atau PhD dari University of Birmingham, United Kingdom. Kemudian Master of Law of Bachelor of Law from University Kebangsaan Malaysia. Beliau sudah lebih dari 18 tahun mengabdikan diri di University Sains Islam Malaysia. Beliau juga aktif dalam beberapa penelitian dan penulisan, khususnya di konsentrasi hukum internasional dan juga hak asasi manusia, kalau tidak salah begitu ya Bu Nina. Jadi salah satunya adalah penelitian terkait dengan human right, kemudian teknologi and the law, kemudian family law atau hukum keluarga ya kalau tidak salah begitu. Kemudian environmental law, kemudian alternative dispute resolution, legal education, dan syariah legal practice. Jadi nanti mahasiswa bisa lebih banyak untuk berdiskusi dengan Bu Dina terkait dengan materi hari ini yang diberikan oleh Wadik 1, yaitu hubungan hukum internasional dan hukum nasional serta yurisdiksi hukum internasional. Nah, materi ini mungkin beberapa mahasiswa sudah masuk pada materi hubungan HI dan HN. Untuk waktu saya persilahkan kepada Bu Dina untuk menyampaikan materi pada pagi hari ini. Silakan Bu Dina.
Baik. Oh my God, hilanglah pula. Terima kasih Ibu Aprilina. Terima kasih mahasiswa kerana hadir pada hari ini. It's my pleasure to be with every one of you today. Saya sangat berterima kasih kepada Fakultas Hukum UTM di atas jemputan ini, di atas pelauan ini, undangan ini. Dan saya berbesar hati untuk berkongsi dengan anak-anak mahasiswa pembentangan ataupun tajuk the topic of my presentation, which is the relationship between international law and national law. Saya suka kongsikan kenapa saya meneliti, why did I choose to study international law. Dulunya saya cuma mengkaji, meneliti, I used to research and study on Malaysian law. But as I move on, especially when I look at human rights, the laws relating to human rights, we have to see the relationship between the national law and the international law, because the national law could have different provisions or different standard or different protection of human rights, and the international law have different protection of human rights. So I look at the interaction between these two laws, the international law and the Malaysian law, to see whether or to see the extent to which international law can benefit the protection of human rights. Dulunya saya cuma mengkaji Malaysian law atau national law, domestic law, tapi lebih banyak saya mengkaji, saya dapati bahawa untuk memperbaiki perlindungan hak asasi manusia di Malaysia, kita perlu melihat kepada standard yang lebih baik. Kita perlu melihat kepada undang-undang atau hukum yang lebih baik. Dan itu saya ketemukan di dalam International Human Rights Law. And that is how I venture into international law, especially in my PhD studies, di dalam penelitian PhD di S3. Saya meneliti tentang pengungsi, refugees. So Malaysia have refugees from several countries, and we do not have a framework. Di Malaysia itu sendiri kita tidak punya framework of protection under the national law, but we have the framework of protection is available in international law. So I look at the interaction of these laws. How can Malaysia benefit? How can refugees or vulnerable people benefit from protection of international law? So I look at how can we apply, how can we bring the international law into our courts. So today, I will share my screen. Okay, bisa nampak ya? Boleh nampak ya skrin saya?
Nampak Bu, nampak.
Bisa Bu, bisa Bu.
Okay. Baik. Okay. Jadi this is the learning outcome. This is what I want to achieve today. Okay. Our achievement or the outcome of this session would be the learners are able to explain the theories of relationship between international law and national law. So at the end, you should understand. You should understand the theories. The theories. We have 3 theories that I will explain. So we hope that at the end of the session, you will understand this relationship. And the second one is your ability. The learners are able to identify the treatment of international law in Indonesia and also in Malaysia. Okay, I will try to explain the treatment of international law in Indonesia. I do not have, maybe I don't have enough knowledge on this, but based on my reading, I will explain to you. But I stand corrected. Ibu Aprilina dan Bapak juga boleh betulkan saya jikalau saya salah when I make mistake when discussing the treatment of international law in Indonesia. Okay. Okay, as an introduction, I hope everyone still remember. I hope you still remember what is international law and what is national law. So when international law, the discussion centers on the word inter. So it's the law that regulates the relationship between nations, between 2 or more nations. And domestic law, also, which is the national law, is referred to or not referred to, is the law within a particular nation, within the state. So you and I'm sure you know this already, ya kita tahu. Setiap negara punya kedaulatan undang-undang atau semua negara berdaulat. We consider ourselves sovereign. Semua negara itu ada kedaulatannya sendiri. Therefore, we have the right to decide how does international law are accepted in our legal system. Okay, Malaysia is a sovereign state. Indonesia is a sovereign state. Kita sama-sama berdaulat. Jadi kita tidak suka kalau orang lain memberitahu kita bahawa kamu perlu terima undang-undang ini, kamu perlu terima hukum ini. Kita tidak sukakan begitu. What we want is, we want to decide for ourselves. Yeah? We want to decide how does international law and international obligation or the rights should be accepted in our legal system. So Malaysia adopt a different style. Indonesia also adopt a different methods. Yeah. So depending on our background, our practice, yeah, we will have different methods. Ya, setiap negara itu mempunyai kaedah, kaedah yang berbeza dalam penerimaan undang-undang antarabangsa. Some countries, some states provides that once international law is ratified, it can become national law or it overrides the national law. But in some countries, they deny the effect of international agreement, unless the law is transformed into national law. You cannot give effect to international law unless you transform that into national law. Okay, so and other countries, for example, they allow customary laws to automatically operate in their country. Yeah? So different country has different style, different method, different approach in accepting international law. Okay, so I am going to discuss with you 3 theories of relationship. The theories of monism, dualism, and also the moderate approach. Yeah? Okay, what is monism? Monism is an understanding or is a concept that that gives similar position, similar rank, to national and international law. So kepada monism, kepada para monis, penyokong-penyokong monis, mereka menganggapkan bahawa undang-undang antarabangsa, hukum internasional dan hukum nasional itu hierarkinya sama, kedudukannya sama. Jadi pada mereka dia hanya adalah national law and international law is a single body, of law, bukan berasingan. Dan monism, monis, para penyokong monis mengatakan bahawa the rules of international law and national law operate in the same sphere. Kedua-duanya, international law dan national law itu in the same sphere. It has similar influence and they are concerned with the same subject matter, which is the individuals. Therefore, no matter what the legal system is, the laws, whether it's regional law, national law, or it's international law, they are bound to deal with individuals. Yeah. So the law, according to Moniz, the law deals, the international law, whatever kind of law that we have, deals with the human, because it's the human, because they only consider human as the entity. So the fundamental element of the society is human. So all laws are treated the same, are considered having the same position, having the same rank. Jadi kesemua jenis hukum menurut Moniz adalah sama, untuk tujuan yang sama, iaitu untuk kepentingan manusia. Okay, jadi kepada Moniz, according to Moniz, national system or international legal system is the same, because it protects the rights and obligation of the of the human, of the mankind, and therefore the rights and obligation between national law and international law is transferable. So if you find protection under international law and it's not there in the national law, it can simply transfer to the national law. This is what monists think. Yeah. Contohnya, for example, some human rights protection are available in national law, and we have an elaborate protection of human rights in the international law. So it does not compete. According to monists, the national law on human rights and international law of human rights does not compete with each other. It should complement and support each other. This is according to monists. Jadi tidak ada pertandingan di antara international law dan juga national law, because monists think they are the same. They complement each other. Dia saling melengkapi, according to monists. Okay, Kelsen, salah seorang scholars in international law, he said that international law derives from the practice of states. National law derives from state as established in international law. Ya, dia mengatakan bahawa hukum-hukum internasional itu diambil daripada amalan-amalan states, state practice. Okay. Okay. Seterusnya, I would like to discuss on dualism. So dualism is in contrary to monism. Dualism is in contrary with monism. Monism, the monists argue that national law are in a similar sphere. They never dualism or dualists. Dualists are scholars who support dualism, the idea of dualism. They argue that international and national law are separate, are distinct, are different systems. And because they are different, they operate in separate compartment, a compartment that cannot mix with each other. They are in a watertight compartment that cannot mix with each other, according to dualists, and they do not operate in the same sphere of influence. According to dualism or dualist, the international law and national law are not only in different legal system, they also have different influence. So they have rank. The dualists are saying that international law and national law has rank. It has its own position. It's not complementary to each other. Okay. According to dualists, international law and national law differ as to their sources, and the relation they regulate and their legal content and application. According to dualists, international law deals with different sets of things, and national law deals with different sets of things. They don't deals with similar things. Aplikasi international law berbeda dengan national law, according to dualists. And according to dualists, they also say that national legal systems are not common. Sistem hukum negara-negara ini berbeza-beza. Jadi dia tidak berinteraksi. It does not interact with the international law because of these differences. Okay, so according to dualists, international law regulates relations between states only, and national law regulates the right and obligation of individuals within the states. And therefore, there is no room for transforming the rights and obligation from one system to another. Because dualists think that international law and national law operates in different spheres with different rank. So to them, international law cannot transform, cannot simply transform from the into the national law. Dia tidak boleh sewenang-wenangnya masuk ke dalam national law atau hukum nasional. Okay, and they also think, dualists claim that the sources and the subject of the international law system and the national law system are different. There are points of conflict, and at times there are points of conflict, and national law operates vertically, where sovereign power of the state is the lawmaker and all others are law abider. While international law operates horizontally, where states are both creator and abider of the law. Dia begini, according to dualists, hukum nasional itu operates vertical, dia ke atas, dia naik ke atas. Bermakna they are a set of people that we have a lawmaker, pembuat undang-undang seperti parlimen, pembuat undang-undang parlimen yang membuat undang-undang, dan kita ada orang ataupun people who follow the law, who has to abide with the law, who has to oblige to the law. That is vertical. But international law, on the other hand, operates horizontally. Dia mendatar. Kerana according to dualist, states create international law, they create international law together, and they have to abide by the international law together. So that is why, according to dualists, the national law and international law are different. Are different. Okay, so the third theory of relationship, this is the third theory of relationship between international and national law, which is the moderate or middle ground. This is the third opinion that explain the relationship between international law and national law. Okay, am I going too fast? Adakah saya terlalu laju atau bagaimana? Are you good? Are you okay? Is everyone okay? Boleh ya?
Yes,
Okay.
boleh.
Baik. Baik. This is the third theory. Ini pendapat yang ketiga. Kita sudah ada dua pendapat yang ekstrim. Satu pendapat mengatakan undang-undang the monist, di bawah monism, under the monism. The monism think that the international law and the national law are similar. They operate in similar spheres, they have similar rank, so they complement each other. The dualists, on the other hand, have contrary view. They contradict the idea of the monist. The dualists think that the international law and national law operate in different system for different subject, and therefore they cannot transform. The international law cannot simply transform into national law because of these differences. So we have the third opinion, the third group or the moderate group that hits the middle ground, yang tengah-tengah, golongan pertengahan. This group of people, or this group, the moderate group, the moderate idea of this relationship looks at the theory of coordination. They look at the relationship as a coordination. It's not confrontation like the monism and dualism. Satu kata boleh, satu kata tak boleh langsung. So the theory, the moderate theory stated that monism and dualism are extreme expression kepada kepada golongan middle ground ini, the theory of monism and dualism are extreme, ya, keterlaluan, ya, because they do not cooperate, dia tidak mahu bekerjasama, dia mahu berkonflik saja, ya. So this group, the third group, argues against dualism, that international and national law interact and intersect. Dia tidak bersetuju dengan pendapat dualism bahawa international law and international law itu tidak bergabung, atau bukan tidak bergabung, tidak ada kena-mengena atau operate differently in separate system. So according to this group, the conflict of international law and national law is not the system but the obligation. Konflik di dalam idea dualism and monism ini is not the system itself, it's actually the obligation created by the international law and the national law. And of course we understand this because national law maybe create different obligation, and national law could create different obligation to the state and also to the people. Okay. It also argues against monism. So this third group counter the idea of monism, that the transfer of rights and obligation as monist claim is not automatic. Dia kata tak boleh automatic. It's not automatic. So dia tak setuju kita kata, they disagree with the idea that the law of the international law and national law are separate. But it also disagree with monism that the transfer of rights and obligation between international law and national law are automatic. Okay, so according to this group, the transfer of rights, pemindahan hak dan juga tanggungjawab is possible. The transfer is possible through incorporation, harmonization and adoption. Dia kata kita boleh ambil obligation itu melalui incorporation, harmonization and adoption. This means there is a mechanism, there must be a mechanism, in which the obligation and the rights can be transferred from one system to another. So they create lah, dia kata kita boleh create, we can create a mechanism in which we can transfer the right and obligation from international law to national law, or from national law to international law. Okay, for example, the European Union plan to harmonize its domestic laws which are in conflict with the international treaties. So for everyone's information, I think you know this, European Union has their set of law, and they have their set of law. Members of European Union, each of them has their own domestic law, and they also have laws applicable to the whole European Union. So some of these law are some of the treaties are in conflict with the domestic laws of the member countries. So what they need to do now is to harmonize them, to harmonize the conflicting provisions of law of the national law. Okay, I hope you can follow me. I think this is, I believe that I am not too fast here. Okay, the dualist view is not quite true, that obligations of international and domestic law are not transferable. Jadi dia tak setujulah, the third group ni disagree with the dualist view that the obligation of international and national law cannot be transferred. Because as we can see, there are many areas of domestic law which are influenced by the international law. For example, our human rights law, even our national human rights law have some influence of the international law. Yeah. Okay, so this group argues that both systems benefit from each other. The international system benefit from the national system benefit from the international law. Okay, and they also agree that international law should not interfere with the internal matters of state, but this is not absolute. Even though we have the principle of non-interference, it's not absolute. Yeah, like the ASEAN countries has this practice, that has this policy of non-interference between states, and therefore, if Malaysia did something, has some practice which Indonesia disagree, yeah, usually Indonesia would not interfere because this is your problem. It's not our business, it's your business, so we will not interfere. However, this non-interference principle is not absolute. Yeah, that is why when what happened in Myanmar, when the Rohingya refugees, when the Rohingya people are being treated unfairly in Myanmar, even though ASEAN countries has this position of non-interference, they issue a statement, yeah, asking the Myanmar authority to do something about the suffering of the Rohingya people in the Arakan territory. Okay, so in short, this group, the third group, the moderate group, argues that it's wrong to argue that the two legal system is in conflict, and or to say that the system are in unity. Dua-dua salah. According to moderate, kita tidak boleh katakan bahawa undang-undang ini dalam kumpulan yang sama. Kita juga tidak boleh mengatakan bahawa undang-undang hukum internasional dan hukum nasional itu berkonflik. Kerana kepada kumpulan ini, according to this group, the law, the both system benefit from each other and it complement each other. Okay, so what become conflict from the international and national system is the obligation. It's not the law itself, but the obligation created under the international and national law can come into conflict. Yeah? For example, we have issues of environment, issues of human rights, global warming, for example. Yeah? So these are the things that this obligation, it's not the law that is in conflict, it's the obligation. When we have environmental issues, or we have cross-border issues such as terrorism, states would have its obligation. So this obligation is actually that come into conflict, not the law. Yeah? Okay, so in conclusion, this is just a temporary conclusion. We have not finished. Yeah, we have not finished. This is only a conclusion on the theory. These are only the theory. Yeah? The theory of relationship between international law and national law. So I can conclude that the national and international legal system operate based on the discussion, yeah, of the monism and dualism. We can say that national and international legal system operate in a different domain, yeah? But there is no presumption of conflict or hostility to each other. We cannot say that they are in conflict with each other. We cannot make that presumption. We can only say that the national and international legal system operate in different domain. Yeah. Both systems are important. Kedua-duanya pun sangat penting. Both systems are important, and it support and interact with each other. Yeah, both laws. Okay. So state has the primary responsibility for the implementation of the human rights, for example, and the responsibility lies with the international authority. The primary responsibility, like this, the primary responsibility to protect or to implement the human rights lies with the state. The secondary responsibility lies with the international law, with the international authority. So the first entity, the first authority responsible to protect the human rights is the state. Okay, the second authority that implement the human rights is the international authority. So we look at the state obligation first, then only we look at the international obligation. So state has to play its role in protecting the human rights. This is an example. State has to play its role in protecting human rights. Then only we can look at the responsibility of, for example, the United Nations in the protection of human rights. So you cannot first look at the obligation of the United Nations, then only you look at state obligation, because state is the primary protector of the human rights. Yeah? Okay. The other conclusion that we can make is that international law is not concerned with domestic law. Yeah? It's not concerned with domestic law unless the domestic law violates its international obligation. Yeah? The obligation that emanates from the international law. So international law, it does not they don't intend to intervene with domestic law unless a state or unless the domestic practice or the national practice infringe or violate the international obligation. For example, when we talk about the environment, the international environmental law does not concern with our domestic law. I mean, they do not want to intervene. They do not want to interfere unless we do something, unless the state do something against its obligation in international law, and that obligation comes from the international law. So when you do this, then only international law will intervene. Yeah? Okay. So we have, for example, the practice in South Africa. Previously, they had this apartheid policy. Yeah, they discriminate between the indigenous black people and the white people. Yeah. So here, the obligation of domestic law is in conflict with the international obligation, because the law says the law discriminates black voters, but at the same time, we have the United Nations Convention on the Elimination of Racial Discrimination 1965 that protect against racial discrimination. So the obligation of domestic law is in conflict. In this situation is in conflict with the international obligation. Okay, I would like to explain a little bit about Malaysia's position, in relation to this issue, the relationship between international law and national law, and what is our perspective. Okay, Malaysia can be said to have been practicing a dualist approach. Yeah, we practice dualist approach towards international law and treaties. And to us, this is perhaps an influence of the British system. Because Malaysia was a British colony, so our legal system is very much influenced by the British. Our, for example, Malaysian law is based on common law, or common law is one of our source of law, and that common law is actually coming from England. Okay, and Malaysia take the view that international law and domestic law or the municipal law are two separate systems, and without superiority effect over each other, as both regulate different subject matter. That is our view. Yeah, in the Malaysian view, we practice dualism, and we maintain, we consider, we believe that international law and domestic law and national law are different systems. They are different systems. Two set of legal system, and they are different. Even though they are different, they do not have superiority effect over each other. And it regulates different subject matter. This is Malaysian stand. However, that is just a theory. Yeah. However, in practice, dualist state often make laws that subjugate the international law. Ya, biasanya dalam amalan negara dualist state ni, mereka akan membuat hukum-hukum nasional yang akan memberikan kesan subjugate, yang akan merendahkan kedudukan hukum internasional. This is of course different, sangat berbeza, in complete disagreement with the monism theory, because the monism treat international law as supreme over national law. Sebab monism akan mengatakan we have to follow the international law. National law is the benchmark. So monism is in complete disagreement with the dualism, because monism considers both international law and national law as a single unit. According to monism, international law is the basic law. Therefore, it will automatically become part of the national law. That is the idea of monism, which Malaysia do not accept in practice. Okay, so I will explain the position of Malaysia. So in Malaysia, the theory, this is just a theory, the national law cannot be invalidated by international law. Just because we ratify an international treatise or convention, for example, the ratification will not operate to invalidate national law. Katakan Malaysia meratifikasi the International Convention on the Rights of a Child. And Malaysia also have its own statutes on children's protection. And both the international law, the convention, and our law are in conflict. But just because we ratify the convention, just because we ratify the international convention, doesn't mean that it can invalidate our national law. Dengan meratifikasi undang-undang hukum-hukum internasional, the convention, the treaties, itu tidak menyebabkan hukum-hukum nasional itu menjadi tidak sah. Okay, for example, I'm explaining to you the position in Malaysia. We have the immigration law, the Immigration Act. In Malaysia, we have the Immigration Act. Under the immigration, we do not have refugees classification, which means anyone from foreign land who come to Malaysia without valid document or without through improper channel will be penalized for email offence. Sesiapa juga yang datang masuk ke Malaysia tanpa dokumen perjalanan yang sah akan didapati bersalah melanggar hukum. Sedangkan according to international law, according to a customary international law, or the principle of non-reformo, state is prohibited from rejecting a refugee, and state is also prohibited from taking criminal actions against refugee. So this is the conflict. This is an example of conflict in Malaysia. While Malaysia do not have laws to regulate refugees, so we treat refugees as similar to other immigrant, sama seperti pekerja asing. Jadi jika mereka itu masuk tanpa dokumen, without passport, without visa, the refugees can be rejected. They cannot be allowed to enter Malaysia. They can be rejected. Or if they are already in Malaysia, they are subject to penalty. They can be charged with criminal offence and subject to penalty. This, what Malaysia practice, is contrary to the principle of non-reformo, because the principle of non-reformo, the rule of non-reformo, this principle prohibit from rejecting refugees, and it also prohibit the convention convention relating to the status of refugees, International Convention, prohibits state from taking criminal action against refugees. So this is an example how Malaysian law come in conflict with the international law. Okay, so in Malaysia, whether we are dualist state or not is actually not in the federal constitution pun. We do not have that position. It's not explained in the constitution. This is actually taken from the application of the law by the courts. Because in Malaysia we consider constitution as the supreme law. So any law which is in contrary to the constitution will be void to the extent of that inconsistencies. Okay, all right. Kita ada berapa lama masa lagi, Pak? Ibu Aprilina, kita ada masa sampai pukul berapa?
Selesainya aja Ibu, sampai selesai enggak apa-apa. Karena sampai
baik.
Bu Dina menjadi selesaikan.
Okay, baik, terima kasih. So in Malaysia, the position would be when we receive or when we ratify international treaties, the only way that we can make that law to have a legal effect in Malaysia is by introducing a law that transform the international law into national law. So in Malaysia, even though we ratify a convention, that convention cannot automatically take effect in Malaysia. Sebab itu kita punya we ratify a number of conventions, but it cannot take effect as long as the Malaysian Parliament has not enacted a specific act to adopt the international law to become national law. So it has the national law must acknowledge, legally acknowledge that certain laws are applicable in Malaysia. So, for example, I give you an example. For example, we have the Geneva Conventions for the protection of the victims of war of 19 1949. Okay, Malaysia ratified that convention, but that convention can only take effect after the Parliament enacted a special act, enacted a special act so that this will become effective in Malaysia. So the Parliament in 1962 enacted Geneva Convention Act 1962, revised in 1993. Okay, so it does not take the provisions of the Geneva Convention per se, but it adopt the provision. Jadi hukum internasional treaties itu, the Geneva Convention itu, dia tidak terus menjadi undang-undang di Malaysia. Dia perlu diterima, dia perlu diterima melalui undang-undang khusus yang diperbuat oleh Parlimen. So in this situation, the Parliament adopt Geneva Convention Act 1962. So this act, this new act, adopt provisions of the 4 Geneva Conventions. Jadi mereka melihat kepada the 4 Geneva Conventions, they take the provisions that they want and they put it into our national convention, so that our national law becomes in harmony with the Geneva Conventions. Okay, we also have Diplomatic Privileges Act 1966. This is based on the Vienna Convention on Diplomatic Relations 1961. We also have International Organization Privileges and Immunities Act 1992, which give effect to the Convention on the Privileges and Immunities of the United Nations 1946. Okay, and we also have Child Act 2001, and the Child Act 2001 gives legal effect to selected provisions of the Convention on the Rights of the Child. So we do not accept the convention entirely. We, under the Child Act 2001, we select certain provisions into our into the act. Okay, so Malaysia is also a state party to many other treaties, but the treaties have not been given full legal effect. We select some provisions and consolidate them into our laws. So this is our practice as a dualist state. Okay, I have explained that the Child Act is an example where we choose certain provisions and make it as our national law. So there are still many other provisions of the United Nations Convention on the Rights of the Child that we have not adopted. Okay, we move on to Indonesian perspective. How does Indonesia treat international law? Okay, what is the Indonesian perspective of the relationship between international law and national law? Okay, I quoted, this is actually my presentation on Indonesian perspective is based on a paper by Simon Butt. Simon Butt wrote an article on Indonesian perspective of the international law, the position of international law in the Indonesian legal system. So I make reference to his paper when I prepare this presentation. So the wording actually come from this paper. Okay, in this paper, Simon Butt quoted Antonio Cassis in his book International Law in a Divided World, not book, article. So Cassis said this, he quoted this, international law cannot stand on its own feet without its crutches. That is, international law cannot work without the constant help cooperation and support of national legal systems. As the German jurist H. Trippel observed in 1923, international laws is like a field marshal who can only give orders to generals. It is solely through the generals that his orders can reach the troops. If the generals do not transmit them to the soldiers in the field, he will lose the battle. Okay. Petikan ini bermaksud hukum internasional itu tidak boleh berdiri sendiri tanpa tongkat. Ya, hukum internasional itu tidak bermakna tanpa tongkat. Dia tidak boleh berdiri sendiri, dia tidak memberi makna kalau dia tidak diberikan bantuan, tidak ada tongkatnya. So hukum internasional itu tidak boleh bergerak tanpa bantuan. Bantuan macam mana? Cooperation and support, tanpa bantuan, tanpa kerjasama dan juga sokongan, dokongan of the sistem hukum nasional. H. Trippel, a German jurist, dia memberikan analogi. Dia mengatakan bahawa international law, hukum internasional itu seperti marshal dalam laskar itu kan, seperti marshal. Marshal hanya boleh memberikan arahan kepada general. General akan memberikan arahan kepada angkatan-angkatan teranya. Jadi bila marshal memberikan arahan kepada general, jika general tidak menyampaikan arahan itu kepada angkatannya, maka pasukannya tidak akan mendapat arahan dan boleh kalah di dalam medan perang. Jadi itulah analoginya. Marshal itu seperti international law. Dia wujud tapi dia tidak akan memberikan manfaat jikalau tidak digunakan, kerana kegunaan itu sangat bergantung kepada sangat bergantung kepada hukum nasional. Ya, hukum nasional lah yang akan mengambil, memberikan kerjasama, memberikan dokongan kepada international system or international law system. Okay, I stand corrected. I stand corrected because this is taken from this article, because I have never made a single research specifically on Indonesian position relating to international law. So according to the article, Indonesia made no explicit choice about how international law enters domestic law. Yeah. Beliau mengatakan Indonesia tidak membuat pilihan secara nyata bagaimana hukum internasional itu boleh diterima di dalam hukum nasional. Kerana perlembagaan Indonesia, the Dustur, the Indonesian Constitution is silent on the status of international law within the Indonesian legal system. And they refer to Mokhtar Kusumadja. Yeah, Kusumadja. I believe he is a scholar. He is a scholar, a respected scholar. And there was also another scholar that I forgot to write here, General, sorry, I don't remember his name, who agree with Professor Mokhtar Kusumadja, who observes that Indonesia does not specify the position of international law in its domestic laws. Menurut Profesor Kusumadja, Indonesia tidak menentukan posisi hukum internasional di dalam hukum nasional. Bagaimanapun, dia merujuk kepada, mengatakan bahawa it doesn't mean that international law is inferior to domestic law in Indonesia. Itu tidak bermakna hukum internasional lebih rendah kedudukannya daripada hukum nasional di Indonesia. Kerana beliau merujuk kepada pengaruh dan warisan Eropah dalam undang-undang, dalam hukum Indonesia. Jadi dia mengkonklusikan bahawa Indonesia is a monistate. So Indonesia has a different standard than Malaysia. Malaysia is a dualist state, while Indonesia is a monist state. Sangat berbeza. Even in the absence of formal ratification or implementing regulations, according to Professor Kusumaja, we should consider ourselves bound by treaties and conventions approved by Indonesia. So according to Professor Kusumaja, walaupun Indonesia tidak meratifikasi treaty-treaty internasional, itu tidak bermakna Indonesia tidak terikat, tidak terikat dengan hukum internasional itu. Jadi the article by Simon Butt refers to some judicial treatment, merujuk kepada beberapa amalan mahkamah, amalan-amalan mahkamah berkaitan undang-undang antarabangsa di dalam membuat keputusan. Okey, saya akan merujuk kepada dua kes, tetapi saya tidaklah merujuk secara mendalam. I will refer to two cases. The one case by the Indonesian Supreme Court and another case by the Constitutional Court. Okay. We refer to the case of Dedi versus Perhutani by the Supreme Court of Indonesia. Okay. In this case, the court quoted or the court said, the court stated that the lower court judges did not erroneously apply the law by adopting rules of international law. The application of the precautionary principle in environmental law was to fill a legal vacuum. The view of the cessation applicant that Article 1365 of the Civil Code could be applied in this case cannot be justified because the enforcement of environmental law is to be performed by the standards of international law. National judges can use rules of international law if they view it as jus cogens. Okay, I like this statement by the Supreme Court of Indonesia because it gives a clear a clear standing relating to international law. Jadi Mahkamah Supreme Court, Mahkamah Agung Indonesia mengatakan bahawa kerana kes ini dalam kes Perhutani, this is the landslide case. Mungkin antara kita ramai yang pernah dengar, mungkin semua pun pernah dengar, pernah baca tentang kes ini. Di dalam kes ini in this case, Perhutani was there was a landslide. There was a landslide, but it was not known the reason, the cause of the landslide. Bukan tak tahu, tapi they cannot make conclusive decision or conclusive finding on who caused the landslide. So the lower court looks at the rules of precautionary principle. Kerana mahkamah mengatakan Perhutani, sebuah syarikat di bawah kerajaan Indonesia, Perhutani sepatutnya mengambil sikap berhati-hati, precautionary principle. They are bound by the principle of precautionary. Principle of precautionary ini adalah prinsip di bawah undang-undang antarabangsa, hukum internasional. Jadi Perhutani is saying that no, it's not right. You cannot use international law to impose that obligation on us. Because this has not been accepted. Undang-undang ini belum diterima oleh Indonesia. Jadi mahkamah mengatakan bahawa that's not right. Mahkamah mengatakan sepatutnya undang-undang itu terpakai, hukum internasional itu terpakai di Indonesia kerana kita perlu penguatkuasaan hukum lingkungan, ya. Environmental tu lingkungan kan. Hukum lingkungan itu perlulah berdasarkan kepada standard hukum internasional. And mahkamah menambah, hakim-hakim boleh menggunakan prinsip-prinsip hukum internasional jika pada pandangan mereka hukum itu adalah berstatus jus cogens. Jus cogens itu kan preemptory rules of international law. Hukum international law atau prinsip jus cogens adalah prinsip dalam hukum internasional yang tidak mesti digunakan, tidak boleh diketepikan dalam apa-apa keadaan sekalipun. So Mahkamah Indonesia boleh menurut Supreme Court Indonesia, hakim-hakim mahkamah di Indonesia boleh, ya, menggunakan prinsip-prinsip hukum internasional jika mereka berpendapat bahawa itu adalah prinsip jus cogens. Okay. Okay, I look at another case in the Constitutional Court. The Constitutional Court, in this article by Simon Butt, the Constitutional Court makes regular reference to international law in its decision. Yeah, the Mahkamah Constitutional Court apa ya? Mahkamah, kalau di Malaysia itu perlembagaan. Saya tak tahu namanya dalam Indonesia ya. So dalam satu case, in a case, Abdul Rahman Wahid case in 2004, you have your former Indonesian president, Abdul Rahman Wahid, together with several others, challenged the constitutional validity of Article 1 of the 2003 election law, because that article stated that candidate for the presidential candidate has to be spiritually and physically capable of performing the duties and responsibilities of president or vice president. Okay, this is the provisions of the law. Yeah, so Abdul Rahman Wahid is challenging the validity of this provision because they argue that this is discriminatory. Yeah, because Abdul Rahman, because they consider that this is discriminatory against Abdul Rahman. Yeah, and therefore, because of its discrimination, it's also it's contrary to Article 27(1) of the Constitution on equality before the law, and it is also in contrary to Article 6(1) of the ICCPR, the International Convention on Civil and Political Rights, which in which Indonesia is also a member. Okay. So dia mengatakan, perayu-perayu pemohon mengatakan bahawa peruntukan di bawah Artikel 1 of the 2003 election law is contrary to Article 27 of the Indonesian Constitution, and it also breached Indonesian international obligation under the ICCPR. Okay, sorry. This is also in contrary to Article 25 of the ICCPR, and but the court say tak perlu pergi jauh-jauh. The court say you should refer to Article 2. You should refer to Article 2 because Article 2 provides the grounds for discrimination, the prohibited grounds for prohibition. And the court also say that the Declaration of Rights of Disabled Persons is the most relevant international convention to the case. If you want to refer, you should have referred to the rights of Declaration on the Rights of Disabled Persons. Ketika ini, when the law when the case was going on, the Declaration of the Rights of Disabled Persons has not become a convention, so it has no legal effect. Yeah. Yeah, however, in the end, even though the court referred to the ICCPR, the court say the election law actually did not discriminate on any of the grounds, on the prohibited grounds under Article 2. Yeah, and the court refers to Article 4 of the Declaration of the Rights of Disabled Persons. It says disabled persons have the same civil and political rights as other human beings. Yeah. The
Ibu
court
Dina,
also referred to Article 21(1). Yeah.
Ibu Dina mohon maaf 5 menit lagi ya, biar nanti teman-teman mahasiswa untuk sesi diskusi. 5 menit lagi Bu.
Maaf, tak dengar Bu.
5
Okay,
minutes again.
okay, 5 minit. Okay. The Constitutional Court also referred to Article 21 of Article 21(1) of the UDHR, the Universal Declaration of Human Rights. Yeah, because the article established the right to take part in the government one's country, whether directly or through a chosen representative. Okay, so the court also emphasized that Indonesian law provide similar protections as under the UDHR. Yeah? Okay. So, sorry. Okay. Okay. So that's all I can say about, I would like to say about the relationship between international law and national law and the perspective of the in Malaysia and also the Indonesian perspective. All right, itu saja Bu.
Baik, thank you Bu Diana. Terima kasih Ibu sudah memberikan banyak sekali materi khususnya kepada adik-adik mahasiswa yang memang semester ini menempuh mata kuliah hukum internasional dan kebetulan yang menjadikan topik diskusi sangat menarik yaitu hubungan kalau dalam mata kuliah kami pada sub pembahasan hubungan HI dan HN. Tadi juga Bu Diana sudah menjelaskan dengan beberapa teori. Jadi ada monisme atau dualisme. Jadi kalau kita dualisme, monisme dan juga tadi ya yang ketiga yaitu teori koordinasi. Begitu kemudian juga menjelaskan bagaimana prakteknya di Malaysia. Gitu. Kalau Malaysia kalau tidak salah lebih condong ke dualisme, gitu ya Bu ya. Penerapan dualisme karena hukum internasional tidak bisa langsung dilaksanakan di Malaysia, harus melalui prosedur terlebih dahulu. Begitu juga sebenarnya kalau di Indonesia tadi disebutkan bagaimana yang disampaikan oleh Mohtar Kusumatmaja, Indonesia tidak memilih secara tegas, tetapi Indonesia pernah menerapkan monisme maupun menerapkan dualisme. Jadi kalau teorinya memang dengan prakteknya kadang tidak bisa sama. Begitu. Baik, untuk tidak berlama-lama saya berikan waktu kepada mahasiswa. Coba kita lihat di kolom chat apakah sudah ada pertanyaan dari mahasiswa. Baik, mungkin bisa langsung disampaikan ya untuk Safira Anindia Putri. Untuk bisa dihidupkan mikrofonnya, ditanyakan langsung kepada Bu Diana. Baru kemudian Farel Fatuberti. Oke, silahkan Safira. Apakah Safira ada? Safira Salwa? Oke, kalau Safira belum ada. Farel Fatuberti. Oke. Mas Farel silakan ditanyakan langsung kepada Bu Diana.
Okay, thank you. Jadi, Mom Tina, my question is little out of topic. It is okay?
Yes, please. Siapa yang bertanya? Saya tak tahu.
Farel.
Farel, Bu Dina.
Okay, silakan Farel.
Okay, my question is, when United Nations will do investigation in some country, for example, investigation for onset of disease, but the country not allow the United Nations to investigation, so they
Saya enggak dengar. Farel, saya enggak dengar.
Oh yeah. Apa sudah it is clear?
Ya, silakan. Sekali lagi saya enggak dengar. I can't hear you.
Okay. The United Nations will do investigation of a country if they have a problem, but the country is do not allowing the United Nations to investigation or rejecting. So they are not give the visa for investigator. So what United Nations give for the country? Are they giving a sanction or just be quiet? Thank you.
Okay. I saw your question in the chat. Ya, Saudara Farel menyatakan bahawa when United Nations wants to conduct an investigation in a country and their team is not allowed to come into a country, what can the United Nations do? Can it give the country a sanction, or should they just be quiet? Okay, thank you. Okay, United Nations is the body, and their relationship with us, with any countries in the world, is based on on the membership. One thing, your membership in the United Nations, and the other thing is the agreement that you have between between you and the United Nations. Okay, the United Nations has to, mereka itu perlu menghormati, ya, mereka perlu menghormati kedaulatan sesebuah negara, dan sama seperti orang lain, pasukan United Nations perlu mendapat visa atau perlu mempunyai kebenaran, mendapat kebenaran untuk masuk ke dalam sesebuah negara. Okay, I'm not sure if there is a law to treat this situation, but if the United Nations has that power to sanction just because they are rejected or they are not allowed to do the investigation, then the United Nations can do that sanction, can impose the sanction. Such as, for example, we have the Security Council. Remember the Security Council of the United Nations? So under the law, regulating the nuclear power, the team, the Security Council team, has the power to go and investigate the nuclear plant in certain countries. Yeah. So based on this, if a country does not cooperate or refuse to allow the team to conduct the investigation, based on the law, the Security Council can impose sanctions. Yeah. But I am not sure, I'm sorry, I'm not sure if we have similar provisions on this. But I know the WHO, yeah, because United Nations has different organization. Under United Nations, they also have different organization to work on on different area. So they have Security Council on security, they have WHO dealing with the issues of health. So it is WHO who should come and investigate. So, but WHO, the relationship between WHO and Indonesia or Malaysia or other countries is based on the agreement. They have an agreement on that. But I'm sorry, I'm not familiar with that. So if that agreement says that you have to allow WHO to come in to conduct investigation and you refuse, jikalau undang-undang hukum itu menyatakan bahawa dalam agreement itu, persetujuan itu menyatakan bahawa negara-negara mesti membenarkan WHO untuk masuk menjalankan penyiasatan, investigation, and if the country refuse to allow, then the repercussion, the consequence of that can be taken. Contohnya sanction, sanction can be taken. Usually they will refer to the agreement, or they will refer to the whatever a term of reference that they have in regulating the relationship between the state and also bodies, the organs of the United Nations, which is WHO in this regards. It is the way to go. Pada pandangan saya, WHO atau United Nations tidak sepatutnya berdiam diri. Dia perlu melakukan sesuatu, memaksa. They should do something to enforce or to compel, to force the state to allow them to come and investigate. Because the purpose of WHO is to allow what you call sharing of knowledge, sharing of technology, and sharing of technology know-how in dealing with disease. So they have the obligation. I'm not sure which convention, I'm not sure which law, but what I know is that states have the obligation to allow the WHO to come in, because WHO can ask the Security Council to some extent, to use their power to force the state to allow WHO team to come in to conduct investigation. But I'm not sure to what extent, sejauh mana, sekuat mana kuasa yang mereka ada itu, saya tidak pasti. But to me, keeping quiet is not what they should do. They have to find any all the avenues. Dia perlu mencari jalan untuk masuk ke dalam sesebuah negara to conduct the investigation. Okay, I hope I answer your question, Farel. Okay, Farel, did I answer your question? Okay, mungkin saya boleh menjawab soalan. Okay, saya boleh menjawab soalan Savira.
Okay, Miss Safira.
Okay.
Apakah suatu negara hanya dapat mengikuti salah satu dari ketiga teori yang ada, atau apakah sebuah negara diperbolehkan untuk tidak mengikuti dari ketiga teori tersebut? Silakan.
Ini terpulang, this is just a theory. You do not follow a theory. Whether you agree or you disagree with the theory. Kita tidak mengikut teori. Kita tidak mengikut teori, bahkan kita cuma sama ada bersetuju atau tidak bersetuju dengan satu-satu teori. Jadi Malaysia sebenarnya tidak terikat untuk menjadi dualist. Tidak terikat kerana sebenarnya di Malaysia itu tidak tertulis di mana-mana undang-undang pun mengatakan bahawa undang-undang itu harus diterima dahulu dan sebagainya. Hukum internasional itu perlu menjadi undang-undang, perlu diterima oleh parlimen dan sebagainya. Dia tidak ditulis. Bahkan amalan Malaysia itu adalah is based on the court, on the decision of the courts. We refer to the decision of the courts. Jadi di lain keadaan, mungkin pada masa akan datang apabila mahkamah lebih terbuka, mungkin mahkamah akan mengatakan yang sebaliknya. Ya. Tapi untuk keadaan sekarang, at the moment, keadaan sekarang, kerana Malaysia itu mengikut tradisi undang-undang England, jadi kita pun mengikut penerimaan hukum internasional di England. Kerana di England penerimaan hukum internasional itu adalah melalui Enabling Act, satu akta yang diperbuat di Parlimen untuk menerima hukum internasional. Jadi Malaysia juga mempraktikkan perkara yang sama. Tetapi itu tidak menghalang daripada Malaysia mengamalkan perkara lain, pendekatan yang lain. Mungkin boleh, tapi dia belum belum diuji di mahkamah. Kerana undang-undang ini kalau mahu dipakai boleh saja, tapi kesahihan, keabsahan undang-undang itu nanti akan diuji ketika dibawa ke mahkamah. Di Malaysia contohnya, kami pernah menghadapi satu keadaan di mana kita mempersoalkan penggunaan undang-undang adat antarabangsa, customary international law. Ya, di sesetengah negara, customary international law itu diterima bulat-bulat. Apabila sesuatu undang-undang, sesuatu hukum is considered as customary international law, it will be accepted as it is in certain states. But in Malaysia, it does not. But the situation can change. Keadaan itu boleh berubah. Dan perubahan itu mungkin boleh bermula daripada parlimen, atau keadaan itu boleh juga perubahan itu boleh juga bermula daripada mahkamah, amalan di mahkamah. Sama macam Indonesia. Kemungkinan saya tidak tahu, kemungkinan di masa akan datang Indonesia boleh mengambil sikap seperti dualist country, boleh, ya. Negara Amerika contohnya tidak juga boleh mengamalkan kedua-duanya, ya. Amerika pada saat-saat tertentu akan mengambil pendekatan monism, dan pada saat-saat yang lain mengambil pendekatan dualism. Jadi kita tidak terikat untuk mengamalkan mana-mana satu teori, kita cuma terima atau tidak terima. Jadi dia terpulang. Kadang-kadang mungkin terkait dengan kepentingan negara. Ya, kepentingan negara. Mungkin juga terkait dengan satu-satu keadaan yang kita tidak boleh jangka. Jadi di masa akan datang itu boleh berubah. To me, this can change. The Malaysian position or the position in Indonesia or other country can change. Okay, ada tak soalan lain? Ada satu lagi soalan dari Cahayaning Utami.
Yes, ma'am. Mungkin Cahayaning Utami ingin menyampaikan sendiri.
Oh, panjang sekali.
Mungkin bisa disingkat inti dari pertanyaannya, karena sepertinya ada 2 pertanyaan, Bunda, dari Cahayaning Utami.
Saya coba membacanya tapi ada perkara yang saya tidak faham.
Iya. Oke, Cahayaning ada? Ada namanya, tidak ada suaranya. Oke, mungkin
Okey, mungkin pertanyaan itu melihat kepada Eurocentric, ya.
Yeah.
Kerana Cahayaning Utami menyatakan kenapa pembuatan hukum internasional itu terlihat Eurocentris. Sepertinya sangat sangat prinsip-prinsip di Eropah. Ya, itu memang pendapat orang Asia memang begitu. Kita rasakan begitu, ya. Kemudian kenapa mereka yang meng-create standardnya, kenapa hanya satu pilihan saja, kemana nilai-nilai lain yang hidup dalam masa itu? Kerana concern saya di hukum laut, maka saya pun meragukan kenapa materi awal hukum laut internasional selalu dimulai dengan masa Romawi dan books of Grotius. Okey, baik. Saya ini bila kita katakan Eurocentric, saya bersetuju, ya, kerana yang mula-mula ingin menghidupkan United Nations itu pun adalah datangnya daripada orang-orang Eropah. Ya, they started off with the League of Nations. Ya, mereka bermula dengan League of Nations dan lama-lama menjadi United Nations. Okey, walaupun ketika walaupun negara-negara semua ada wakilnya, ya, ada wakilnya di dalam perhimpunan bangsa-bangsa bersatu itu, di dalam perhimpunan United Nations, tetapi mungkin kerana ketika perbincangan itu, proses perbincangan itu berlaku ketidakseimbangan, ya, mungkin kerana itu berlaku ketidakseimbangan di dalam perbincangan, di dalam musyawarah, di dalam conference dan seminar yang berlaku di dalam United Nations itu, maka itulah berlakunya Eurocentris, ya, mereka yang hanya melihat kepada nilai-nilai Europe. Kerana orang Eropah kebanyakannya melihat bahawa nilai Eropah lah yang universal, yang mereka melihat itu. Sedangkan kita pula, ya, orang Asia selalu mengatakan bahawa we always claim that we have different set of standards, different set of norms, the Asian norms, the Asian values. Kita merasakan the Asian values are different than the European values. Sedangkan orang-orang Eropah pula menganggap bahawa European values itu adalah universal, itu kepada mereka. Saya tidak dapat menjawab kenapa mereka yang mengkreatkan standardnya, tapi jikalau kita melihat kepada hukum-hukum internasional, sebenarnya terdapat banyak pengaruh Islam, ya, ada banyak pengaruh Islam di dalam hukum-hukum internasional. Ya, Grotius umpamanya, dia dikabarkan pernah merujuk kepada kitab-kitab Islam, ya, the principles of Islamic laws. Ya, Grotius dikabarkan begitu, tapi saya belum pernah mengkaji Grotius secara mendalam, tapi saya pernah terbaca, ya, bahawa Grotius sendiri pun adalah dipengaruhi oleh prinsip idea-ideanya sebenarnya dipengaruhi oleh prinsip-prinsip prinsip-prinsip Islam dalam dalam hukum antarabangsa atau nasional. Okey, untuk menjawab Eurocentric itu, saya katakan berlaku ketidakseimbangan ketika ketika mereka bersidang untuk membincangkan tentang satu-satu standard, ya, satu-satu convention, ya, ataupun treaty. Kita tahu bahawa orang-orang Eropah ini kuat meneliti. Mereka selalu mengkaji. They often do research. Whatever they want to do, they always back up the data with research. Ya. Mungkin berlaku keadaan di mana orang Asia atau orang-orang lain pun are there in the conference, dalam persidangan, dalam perhimpunan, tetapi mereka tidak ada fakta-fakta data mereka itu tidak kuat. Jadi apabila mereka mencadangkan sesuatu, mungkin cadangan itu tidak boleh diterima kerana tidak ada fakta, tidak ada data yang boleh mendukung. Bagaimanapun, saya tidak boleh katakan Eurocentris itu tidak bagus kerana mungkin ada walaupun dia Eurocentris tetapi prinsip itu bagus dan sepatutnya diikuti oleh negara-negara lain. Contoh saya bagi satu contoh ya. One example, kita punya into the centris. Ya, di selepas Perang Dunia, pertubuhan yang satu pertubuhan dibuat untuk melindungi pengungsi-pengungsi tadi, refugees, sebenarnya adalah untuk melindungi pengungsi daripada Eropah ketika itu. Jadi itu sangat sentrik sebenarnya lekan dengan perlindungan. Tapi lama kelamaan pengungsi-pengungsi ini bukan hanya ada di Eropah, bahkan ada di Afrika dan juga ada di Asia. Jadi telah ada pengungsi, the refugees are all over the world. It's no longer in the Europe. Jadi standard yang pada Eropah kan penggunaannya untuk pengungsi-pengungsi refugees yang berada di negara-negara lain, berada di Eropah, bukan hanya di Eropah, bahkan di Indonesia, di Asia dan juga di benua Afrika. Tapi standardnya itu sebenarnya sangat bermanfaat untuk perlindungan menteri, tetapi ia sangat ada di mana mereka berada. Jadi pada saya, Eurocentrik walaupun nampak seolah-olah tidak mengambil kira standard Malaysia atau standard Indonesia, tapi ia bersifat universal. Dia bersifat universal. Dia sebenarnya bagus untuk menjaga hak asasi manusia contohnya. Jadi saya tidak boleh katakan bahawa Eurocentrik itu tidak bagus semuanya. Dia mungkin banyak kepada kalau kita katakan Eurocentris ini contohnya dia memberikan terlalu banyak kebebasan, complete freedom of speech atau complete freedom of religion yang sangat berbeza dengan value nilai-nilai ketimuran, mungkin berbeza dengan nilai ketimuran. Okey, saya harap itu menjawab persoalan daripada Cahaya Ning Utami.
Bu Dina, mungkin satu pertanyaan lagi sebelum kita sudahi sesi diskusi karena 10.30 sudah ada kegiatan lain untuk teman-teman mahasiswa.
Okey. Ada soalan dari Dinda tapi saya pemberkasan
mungkin
maaf,
pertanyaan Rohma Safitri yang lebih kepada contoh tadi.
Assalamualaikum warahmatullahi wabarakatuh. Miss Dina, I want to ask some question. Before that, I'm sorry interrupting your time. My question is, which countries have relations with Malaysian country regarding the extradition agreement? We can look what Indonesia country have a relation have relation with other country for extradition agreement. There are several country extradition agreement. Example for Malaysia, Philippines, Thailand, Australia, Hong Kong, South Korea, and Singapore. And just like this, my question. Thank you for your attention.
Okay, thank you, Rahma. Do you know whether Malaysia has extradition agreement with Indonesia?
Yes, Ms. Tina.
Rahma? Rahma?
Yes.
Okay. Yes. Okay. Yes. Extradition is based on bilateral agreement. Yeah. We do not have a standard agreement for all countries. So it's based on bilateral agreement. So Malaysia do not have with some countries we do not have. I do not have the list, but I know that Malaysia has extradition agreement with Indonesia, with Australia. Yeah, we also have extradition agreement with Singapore, with Hong Kong. What else? Yeah, so we have some bilateral extradition agreement with some countries, but I'm sorry, I do not have the list. Yeah, but I can we can check. I think we can Google that. Yeah, we can find that the list later. Okay. Okay. I think that is all the question about the extradition, kan? Because you only asked about which country has extradition agreement with Malaysia. I think Malaysia has extradition agreement with many countries. Okay.
Okay.
Okay, I have the one. We have extradition agreement with Brunei, with Cambodia, with Laos. So within the ASEAN countries, we have, I think we have all, with Philippines, with Myanmar, with Vietnam and Thailand. So out of ASEAN, we have Australia, Hong Kong, America, UK, India, and Korea. And so far. Okay.
Thank you, Miss Dina. Teman-teman mahasiswa sekalian, mohon maaf bagi banyak chat yang belum bisa dibacakan satu persatu. Insya Allah nanti setelah selesai diskusi ini akan kita share materi yang disampaikan oleh Ibu Dina, dan semoga apa yang disampaikan Ibu Dina memberikan manfaat kepada kita dan menambah pengetahuan kita, khususnya materi hukum internasional, karena nanti rencananya akan ada visiting lecture lagi, insya Allah mungkin tanggal 1, dan akan diinfokan kepada teman-teman di grup masing-masing. Kepada Ibu Dina, terima kasih sekali atas waktu dan juga penjelasannya. Saya selaku moderator juga mendampingi pada pagi hari ini. Mohon maaf yang sebesar-besarnya. Jika masih terdapat banyak kekurangan dan kesalahan, insya Allah kita bisa bertemu di kemudian hari dalam keadaan yang sehat. Cukup sekian. Sebelum itu kita foto bersama terlebih dahulu. Bagi yang masih dimatikan kameranya, silakan dihidupkan. Kita senyum dan kita foto bersama. Baik ya, oke. Yang masih kita sesi foto terlebih dahulu 1-2 menit. 1 menit saya rasa cukup ya. Baik, 1, 2, 3. Terima kasih. Sampai berjumpa. Selamat pagi. Assalamualaikum warahmatullahi wabarakatuh. Istina, terima kasih.
Terima kasih.
Terima kasih Bu Dina.
Terima kasih.
Waalaikumsalam warahmatullahi wabarakatuh.
Jumpa lagi nanti.
Ibu, selamat berjumpa Ibu.
Terima kasih,
See you.
Mas tuh.
Bye-bye,
See you,
Cikgu.
Ibu.
Cikgu.
Waalaikumsalam warahmatullahi wabarakatuh.